Thank you for participating in the NIA and NHLBI Entrepreneur Workshop Series. This workshop covers the topic of intellectual property. This breakout room, moderated by Don Rose, discusses the topic of working with university-owned IP.
It did require a lawyer if you wanted a lawyer, but you didn't necessarily have to have a lawyer because it was, in a sense, pre-negotiated, and most of the lawyers had weighed in on it already. So it was nice because it saved lawyer fees. But if you don't have an express license, or you don't have some sort of template license with the university that you're working with, then sometimes you do need a lawyer to help you with some of the terms and help you work through that. What I will say is that in the startup stage, many attorneys will provide advice on a pro bono basis, or they'll provide deferred fees. So don't be afraid to ask for those from an attorney. They may ask for a small piece of equity. They may say, well, we'll give you would like to have 2% equity of your company, and we'll provide a year of support or something of that nature. So attorneys are usually pretty flexible when it comes to startup companies, if they feel like the startup company has something that you are, that's worth their time, quite frankly. They love to develop clients, but they want to develop the right kind of client. So you kind of have to sell your technology, or you sell your business to the attorneys if you want to try to get some pro bono work. So it's a little bit of a sales job, and I don't want to say sales in a negative way, but you have to promote your idea to them so that they understand what you're doing and why it's important. Another question that came up was, have university tech transfer offices got a more realistic perspective on licensing their IP to companies than 5 to 10 years ago? I'd say in general, yes. I would say that just as an example, 10 years ago, when I came to UNC, there was not much emphasis on startup companies. In fact, when I went to Autumn, which was the Association of University Technology Managers, which I thought was a season, but turns out it's actually a professional group. When I went to my first Autumn meeting, I think startup was mentioned 2 or 3 times in the entire meeting. It was all about licensing to large companies. That was kind of the emphasis. And if you go back to Autumn now, you'll see lots of emphasis on startups. And so I think what's happened is that the kind of entrepreneurship and innovation fervor that is happening on a lot of campuses, especially on the undergraduate side, has spilled over into the tech transfer side. And younger faculty are coming in saying, well, I want to do my research, but I also want to be involved in a startup company somehow. And so tech transfer offices have gotten more cognizant and more flexible when it comes to licensing, especially for startup companies. And I think TTOs also realize that they have a responsibility to get this out into the public through whatever means that can be. And given the fact that most IP from universities is very early, startup companies tend to be, I think, the best way to get things out, because most large companies aren't going to take something that is very early like this. And I also mentioned the express license. That's a change in perspective as well. The idea of having a template license and having a license also with no upfront fees. So if you look at your standard kind of run-of-the-mill license from university, it'll have some big upfront fee for payment. And as you know, most startup companies don't have money. And so universities have kind of changed their tune, and they may even offer 2 licenses. They may have a kind of big company license, and then they have a startup license. So I'd say, yes, the whether it's realistic or not, I don't know. They definitely have changed their perspective in terms of licensing. So one question was, what are reasonable terms to expect when a faculty negotiates with the university? What leverage do we have? So in terms of reasonable terms, as you know, it's in the eyes of the beholder. I think that I would say that equity is something we can talk about when we get to talk about terms. That can range anywhere from 5 to 20% with some other things associated with that. Royalties can range from 1 to 3% to 5%, depending if it's an FDA approved product or not, things of that nature. What I will say in that question, it kind of raises an issue about a faculty member negotiates. So many universities will not allow that. They won't allow faculty to negotiate because it creates a bit of a conflict of interest where the faculty is negotiating with the university. So the faculty, in a sense, is negotiating with their own employer over this thing. And so many require a lawyer. So that's a good reason to have a lawyer, because your lawyer can do the negotiation on the company's behalf, but also on the faculty member's behalf. Or if you have a CEO or some other management person that's not a university employee, then that could work as well. Other part of that question is, what leverage do we have? Hard to say. I guess it depends on your status in the university. And I think the biggest leverage is showing enthusiasm and showing a plan for commercializing technology. I think the last thing a TTO office wants is somebody who wants to license technology without a plan and without any money or without a management team. So if you don't have any of those components, then you don't have much leverage, because they're not very interested in licensing to people who don't have a plan, don't have money, and at least don't have a skeletal management team together. If I move to a new institution, how does that affect my previous IP? So the IP that you invented stays with the university. It is it's again, according to Bayh-Dole, the money that went to that university for that research that generated the innovation, that intellectual property stays with that university. But what's implied in that question is, if you go to another university and develop additional IP, or wasn't asked here, but I'll go ahead and address it. If you collaborate with somebody at another university and generate IP between the two universities, then there's something called an interinstitutional agreement, where the different universities will agree to certain terms, and one university will take the lead on that asset. If it's jointly owned by the two universities, that'll be how they handle that. So I'm about halfway through this series of questions, but I do want to open it up. Anybody has anything specific that maybe we haven't covered quite yet, and just to kind of a little bit of interaction here. So if you have something, just raise your hand and we'll open the floor up to you. Don't be shy. Okay, I don't see anything. I don't think I see any raised hands on my screen. So we'll continue on. So if things come up, feel free to raise your hand, and we'll take your question if I haven't covered it yet. Question comes up: how to handle IP jointly owned by university and company. So the question is, where does this come from? So again, it could come from the fact that a faculty member is consulting with a company, and there could be some jointly owned IP there. It could be an STTR, where you have university doing some of the work on behalf of the company. And if that happens, then you may have this joint IP that arises. And what typically happens is there's some sort of agreement about how to handle the joint IP. Certainly, they can't license it to anybody else because it's jointly owned by the two of you, unless you give them permission to license to somebody else. But there'll be questions about, or the agreement will cover things like who pays for what, and how is the, if there's an infringement, who handles the infringement prosecution and things of that nature. So Peter, you had a question. Go ahead and unmute yourself and let us know what your question is.
Hi, yes. I sort of put that question into you earlier, but the basic idea is that we expect to have a phase 2 contract fairly soon. So we're going to be providing a contract to a partner university, and we're small business. And what can we reasonably attain in terms of ownership of the technology that the university is working on, since the contract is coming from the small company?
Sure. So first, let's just kind of parse it out in terms of intellectual property. If the university owns intellectual property today that you haven't licensed, then that you haven't been working on as a small company, then that is owned by them and will be licensed fully, into into your company. If you're doing this subcontract, then you'll have to negotiate ahead of time the event, what happens in the event of intellectual property that's developed as part of that. So you have to parse out the intellectual property of what existed prior to the contract and what could exist when the contract goes forward. Now, the contract just may be a contract. In other words, they may be working on the intellectual property, but there may not be any new discoveries or new intellectual property generated. So don't assume that there's going to be anything, but you should be prepared for that. So some sort of agreement should be in place that talks about any intellectual property that comes out of this contract. And it's likely the university will say it's jointly owned. Okay. Because it is sort of a collaborative sort of thing. And there's probably not much around that. What you want is some sort of first right of refusal or first right of negotiation to license that. And it may be automatic. They may just say it's automatically licensed by your company, but jointly owned, and here are the terms of that joint ownership. Does that help?
Yeah, it does help. I'm looking at foreground IP that would be created as part of this contract. Okay. They did provide like a write-up of the basic idea of what we would be doing. The question became, is this new intellectual property that would be created under this contract, or would it be, let's say that A is what they're creating, B is what we currently have at our company. Will A plus B equal something novel and patentable? We'll have to figure that out moving forward. But the main question is, if it's foreground IP, then there's joint ownership that can happen. But you said licensing. I got a little confused with that.
Well, I'm talking about licensing of IP that is not part of this, that doesn't come out of this agreement. So if you haven't licensed something, then you should probably button that up first, because if there's IP at the university that hasn't been licensed, that's what I was mentioning. I assume that there was some IP that exists today that would need to be licensed.
Okay. Yeah, we have to clear up if the write-up that they did for the proposal, if that's considered background IP, and I don't know the answer to that yet.
Yeah. I think you might need to get a lawyer involved.
Okay. Thank you.
Yep. So one of the questions that came in was, when is it necessary to license IP from the university? That's kind of a judgment call to a certain extent, because the sooner you license it, the sooner you get it. So it can't be licensed to somebody else. But the sooner you license it, the sooner you have to start paying bills on it. And so, but those bills are going to accumulate anyways. And so it's not like you're saving yourself anything by waiting. So I'd say sooner than later is what you want to do. Hang on one second. So I think, yeah, sooner than later is probably your best choice there. So how can a small business protect IP when working with the academic institutions under small STTR business grants? I think we covered some of that. There's going to probably be some sort of joint ownership of any intellectual property that comes out of that. So you would be responsible for negotiating with the university around that joint IP and how that, and they do this a lot. So it's not like they've never seen an STTR before. It's really about kind of what rights do you retain from that. So one question that came in that I'm not real clear on, but it says, what are my options if I co-own the IP with my employer? So if it's an academic institution, there is no real co-ownership per se. It's the university owns it all because, according to Bayh-Dole, they were given title to it through that. Now, having said that, some universities will give rights to the IP back to the inventors if the university decides they are not going to, if they're not going to pursue the intellectual property. So the filings and the prosecution and that kind of thing. It's rare, but it can be it can be something that happens sometimes when, in fact, I started a company around that when universities said, we're not going to pursue this IP. We're going to give it back to you as an inventor, or as a faculty member. Faculty member brought it to us, and we started a company around it. Universities don't like to do that these days, but they could do that. There's a question here about how to negotiate. Again, if you're faculty, you're not going to be involved in the negotiation process. But what I would say is, in terms of negotiation with universities, is to really understand the university perspective and what they're trying to get out of this. Financial return is just one aspect of what they're trying to get out of this. I think that their obligation to get science and technology and innovation out into the commercial world is a big driver of this. I think that covering their costs, at least for the patents, you have to understand tech transfer offices patent a bunch of losers, things that never go anywhere. And so those patents that get funded that never get licensed, they have to cover those costs. And so that's why they're under a pressure all the time, because they take risks by filing patents that either never get licensed or filing patents that get licensed to companies that never take them anywhere. And so that's the constraint that many of them are under, is how do they get some financial return, mostly to cover the lost leaders and cover whatever salaries and things that they've got within their department. One thing you may want to ask when you go into negotiation is, how are the royalties split among the different participants, the inventors and the university and so on? So just as an example, at University of North Carolina, 40% of the proceeds from a license agreement go to the inventors, split among the inventors equally. 40% goes to the inventors' originating departments, and 20% goes to the tech transfer office. Every university is different. I've seen 30-30-30 or 33-33-33. I've seen other splits. So that may give you some perspective of kind of how when you go to negotiate, what that looks like. One of the questions that comes in is, what are the pitfalls and how to avoid them? I would say that, again, back to this idea of not understanding the perspective of the university and the TTO and what they're trying to accomplish is an important part of that. You, by understanding that, you can, I think, come to a better conclusion at the end. One of the biggest pitfalls that's kind of early stage that's hard to, well, like I say, two pitfalls that come about. One is, and this happens all the time because universities don't have much money, is they only file US protection. And for some cases, that's okay. But if you're in the drug device diagnostic healthcare space, more than likely you want international protection, which is expensive. And so sometimes you'll have some intellectual property that will only be by just US only. So that's a red flag. It's also something that has to be dealt with, and that's a pitfall that can come up, and you may be able to help out by funding some of the international filings. And then there's a second pitfall there, but I can't quite remember what it was in terms of working with universities, but we'll move on. Okay, we have some other questions that have come in, and let me see. This person says, so this is Jen, who says, I disclosed a couple of inventions. The university took one to file a patent, but release for others. Do I have to worry about university coming back and claim things later on for those released inventions? Especially one of them are kind of an extension of the original one. I'm moving to university soon. Okay, that's a good complicated situation. The reason universities don't like releasing is exactly for this situation. Let's say, Jen, that university released the IP to you and you weren't moving to another university, but they released it to you and you continue to work on it, make improvements on it. So now you have your own personal IP that was released to you that you've made improvements on, and the university says, well, who owns that? So I would say that you just have to be really clear up front about improvements to the IP. If you make improvements, who owns those improvements? And if they're funded by an outside source like the federal government, then that could be that can be a problem. So that's one. Can you help me understand what interest the various parties have in this type of negotiation? Is it possible that one or more parties has a conflict of interest? So that's why I mentioned earlier that faculty don't typically have a role in the negotiation. There's an inherent kind of conflict of interest in the university is actually negotiating in all this, which isn't talked about, but they have somewhat of a conflict in the fact that they're employing people and they're doing this activity and then they're negotiating for these certain rights. But I would say that the stakeholders, of course, are the university, the tech transfer office, and then the company and its interest, its shareholder interest. And those are the two big stakeholders in this. The faculty really should be on the sideline to a certain extent because they shouldn't be involved in the negotiating process. Now we haven't talked about conflicts of interest as it relates to the faculty working at or being involved with the startup company. That's another whole. We won't get into COI because that's another whole can of worms that we could spend an hour on. Let me do one more and then we'll open it back up again to see if anybody has any questions, general questions before we kind of jump into the terms. I'm expecting to get an STTR grant. And by the way, if you have questions that you want to send through the chat, don't send them to me directly. Put them in the chat for everyone. That way we can kind of cut and paste it over to this document that I'm working off of because I can't read the chat. There's too many moving parts over there. I'm expecting to get an STTR grant. When the university asked for me to pay past fee and future fees for the patent application, does this mean I'll own the patent? So you'll never own the patent. The patent is owned by the federal government, technically, but title is given to the university per Bayh-Dole, which really created the whole tech transfer process in the 1980s. But what they're asking for are these fees that are part of the license agreement. So those fees shouldn't just be paid outside of a license agreement. They should be paid as part of the license agreement. But again, those are fees to the university for them to then prosecute the patent and pay the attorneys that they're working with. I don't know if folks know this, but it's rare that you have attorneys on staff at universities doing these sorts of things. Many times there's outside counsel that's representing the university to prosecute that. Which actually, I want to bring up one slight aspect of this, and that is representation. So if you're a faculty and you are interested in getting legal advice about your patents that are being prosecuted by the university, as a faculty member, you can't go and seek outside intellectual property counsel for advice. Your company can, and your company and whoever's part of that company can seek that outside counsel, but you can't be represented as a faculty member. You can't be represented by two different legal entities. So just a small note there for that. So let me open it up. Anybody will raise a hand, have a comment about what I've already talked about, questions. Down in the reaction thing at the bottom of your screen, you can click on raise hand and you should come up with your box at the top of the screen for me to see. John Reinhardt.
Hey, Don. One of the questions I had when working with OTT was the guidance to inventors on publishing articles or publishing papers about intellectual property before they had these agreements in place. Can you comment on that, maybe?
Great question. Yeah, we didn't really cover that, but it basically is that if you publish before you file your patent, and of course we're not in the breakout room for the patent process, but typically it's a provisional patent that's filed. If you submit your publication and it's published either as an abstract or as a poster or even a public presentation, then that creates prior art, as they call it. as a disclosure, so that you still have a year window to get some protection back. But the general advice for most folks is to get the patent application in first, and then have the disclosure that comes up through the publication or the meeting or things of that nature. And that provisional patent can be very simple. It can be a pre-publication. It can be something, a manuscript. It doesn't have to be a formal application. So they can do what they call a cover sheet provisional. That's very simple to do, but at least it gives you a date by which you can call it that you've filed your patent application, and that frees you up to do the publication. Okay. Okay, so someone asked about terms. We're going to go talk about terms in a bit. If our patents are owned by the government, what can they do to our patents as the owner? So the patents are owned by the government if the government funded the research that led to the invention. So just be clear about that. If NIA, for example, funds a university faculty member and they come up with an invention, the government owns that invention because they paid for it, just like any other. Follow the money is really where you need to go. If a private industry, if Pfizer or Medtronic funds research in a lab, they'll have rights to whatever intellectual property that comes out of that as well. So it's follow the money. So when the federal government owns the patent, they give title again to the university, who then licenses it to the startup company. So that's how the ownership is. You don't own the license. I mean, you own the license, but you don't own the patents or the intellectual property. You have freedom. A license agreement basically gives the company freedom to manufacture and sell the product without being sued. So it protects you from being sued by the owner of the intellectual property. Okay, so before we get to terms, we have just a few minutes left. Pros and cons of university-owned IP. The pro is that universities will typically take a risk and file patent applications on behalf of faculty. So they will take some of the financial burden off. The con is that they have to typically file early because they're up against a publication deadline or something. And so that means that you've got intellectual property time, a clock that's ticking, which is going to lead in an expiration that's later. Now, if it's a drug, that means that can be critical. If a 20-year lifespan of a drug application or drug patent, the drug may not get on the market for 15 years, which only leaves 5 years of exclusivity of the patent itself. Okay, I think that's all we're going to talk about in terms of general things. So I'm going to talk about specific terms and just group them into 3 buckets. The first bucket is going to be kind of the scope of the license agreement that you could be looking at. And this could be, the first is exclusivity. And I would say that for a startup company, you must have an exclusive license. So preferably exclusive worldwide, which is the geography piece of that. But if you don't have an exclusive license, many times it's hard to get investment if you don't have an exclusive license. There's also the scope can include the application area. Is your technology going to be used for oncology applications or aging applications or things of that nature? So those are kind of that's the breadth of the scope of how you can use this intellectual property. So they're going to give you that. They're going to give you that sort of scope. So we are at the top, coming to the top of the hour at 4 o'clock. We typically go past the top of the hour for anybody who wants to stay around. I can get through some more questions, do a little more Q&A. But if you want to pop off at any time, or we understand folks have things to do, so I don't want to keep anybody, but we may go past the top with a few more of these things. So scope is kind of the first bucket of terms you may have to deal with. The second is what's called consideration. It's a funny word. Basically, it's what does the university get for licensing you this intellectual property. And there are a bunch of considerations, financial and non-financial, but most of them are financial, that the university can get. So an upfront payment fee, typically not used in a startup company situation because startup companies don't have any upfront money to pay, but big companies do. And so they usually expect a big company to provide some upfront payments. Reimbursement of patent costs, both past patent cost and future patent costs. Those are pretty much non-negotiable. You'll have to pay those. Royalties on sale of product. There'll be some aspect of that will, it can again range from 1% to 5%, depending on the kind of the, whether it's FDA approved or not FDA approved. There'll be some milestone payments as part of that. And then, so that means if you achieve, say, an IND or first in man or some milestone of sales, you may owe them some money beyond just where you are today. And the last one is equity. So many universities will take equity ownership in your company as part of the license agreement. There's a wide range of what they'll take. And there's a wide range of what the expectations around that. So for example, they may say, we want 10% equity. And then they get 10% equity if that's how you negotiate it. They may say, we want 5% equity, but it's non-diluted. And we can talk about dilution some other time, but it's non-dilutive or non-diluted up until your first $1 million of equity investment. So that may be a stipulation they put in there. And again, don't have time to go into all those details, but those are the kinds of flavors of equity that you might see. And then the third bucket are kind of diligence sort of requirements. So these are milestones or things that are required, like in a startup company, maybe a management team in place by a certain date, or a business plan in place by a certain date, or things of that nature. So those diligence milestones are typically there to ensure that you're making progress. And if you're not, then you have to go back and renegotiate or talk about, what the repercussions could be if you're not making the progress that you can make there. One term I didn't talk about that falls into one of these buckets, I'm not really sure, but is the ability to sublicense. And for a lot of the technologies, you want the ability to sublicense your technology to somebody else. And what are the terms of that sublicense? Because that could be an important part of your business model. Okay, it is 4 o'clock, and there are lots of terms we can talk about. But I want to open it up to the group to see what questions folks may have. Question came in about, is it a good strategy to delay filing a patent as long as possible to hold a longer patent term by not disclosing anything confidential to grant review agencies? Well, I think you can disclose confidential information to the grant review agencies and note it as such, and you're okay there. But sure, in general, if you don't think it's going to be scooped by somebody else, then delaying it is a great idea. And then you can get longer patent life. The problem is that many faculty need publications, or graduate students need to get out and get a job, and so they have to publish their results. And so that's the pressure. That's probably the biggest issue when it comes to intellectual property from the university, is that it's typically filed way too early because of these pressures for funding and for grants and just career development in general. Okay, in terms of reasonable terms for license agreements, I think I've gone through a bunch of those. Yeah, so I don't know what, again, reasonable is, that's why an attorney is really good. So if you have a local attorney who has been through this process with that same university or other universities, they can provide some good perspective on that. And then this AUTM, Autumn, also has things that are workshops and things that can help you with kind of understanding what's reasonable for startups. Now, again, think about the perspective of the university. They want to get this out and they want to get it into the hands of the public. So if they can't be reasonable, if they can't get the deal done, then that is not good for them. It's not good for everybody. So someone asked the question, how have things changed in the last 5 or 10 years? I would say that universities are less about protecting the family jewels and now much more about getting things out. So they're willing to leave a little bit of money on the table to get things out the door compared to years past. Okay, are there any other questions? Otherwise, we can return to the main room, or we can leave the meeting, whichever your choice is. Last call for questions by raising your hand. Okay, well, I can look at some of these here. So Peter, the small business contracts, the university using phase 2. I understand the foreground IP can be co-owned with the university, but does that mean that the university files a patent application and is titled between the university and the small business? Can the small business apply for the patent? That's to be negotiated with the university. So they, different universities can handle it different ways. So you'll have to just talk to them and see what they've done in the past and see how negotiable that could be. Really what it comes down to at the end of the day is kind of shared responsibilities and really shared economics for the patent. It's unlikely you'll lose the IP because they're not going to license it to anybody else, because how could they? Because it's co-owned by you, and no one would touch it since it was co-owned by you. So not too worried about it. It's just more working out who takes the lead and who pays for what. Okay. Anything else in the chat, or anybody want to raise a hand? I'm just scanning back through some of these. All right. Well, thank you very much, and look at the next workshops and hope to see you there. Take care.